Hello and welcome to our webinar on the updates to the IPC Guide to Exemptions. Today we're going to walk you through some of the more substantial updates to the guide.
So the guide first came out in the spring of 2015, and some of you may recall Danielle and I had done a rollout at that time and met a lot of you and went through the guide. But we'll do a little bit of that right now just for those of you that didn't get to attend the rollout. So the guide to exemptions, the purpose of it is to assist parties in applying FOIP and LA FOIP, particularly FOIP coordinators who have to look at exemptions and figure out whether they apply to the information or not. The guide has a number of tests and interpretations, criteria, definitions that come out of former decisions by the current commissioner, commissioners past with the Saskatchewan IPC, commissioners from other provinces, and then also court decisions. And it is an evergreen document because there are decisions coming out regularly. The tests and definitions change. So we will be updating the guide and also growing the guide as time goes on. And at the bottom, you will see in the footnote, in the footer, that there is a date. Always use the online version because then you know you've got the most updated version. So this version right now will say June 13th, 2016. We're going to start off talking about 19.1a. There's some updates to 19.1a that Danielle's going to talk about. Before we do that, I'm going to tell you a little bit about another change that we've made as far as navigation through the guide. You're going to find on the updated version that it will open by default with this index down the side, and you'll be able to just click on these and move to where you need to. The same goes for the table of contents. It is interactive, so you can actually click and it'll take you right there. The nice thing about this is you can go back and forth between sections. So hopefully that is of assistance to you. And we'll start with 19.1a.
So for this section, our office has updated the four-part test that is used to determine if information qualifies as a trade secret. So the test has been updated to reflect the four-part test found in the 2012 Merck-Frost Supreme Court of Canada decision. So the test reads as follows. The information must be secret in an absolute or relative sense. The possessor of the information must demonstrate he or she has acted with the intention to treat the information as secret. The information must be capable of industrial or commercial application, and the possessor must have an interest worthy of legal protection.
The other place that trade secret appears in the Act is 18.1a as well, so you'll see the definition will be different in 18.1a. So now we're going to talk a little bit about some changes. 19.1c. So 19.1c is the first place in FOIP and LA FOIP where you're going to see a harms-based exemption. And as you know, there's two types of exemptions in Part 3 of FOIP and LA FOIP, class-based exemptions and harm-based exemptions. So for the harm-based exemptions, there's some type of harm that's being contemplated. Previously, our office had a test that we called the harms test. And what we've done with the update to the guide is made sure that the harms test is actually consistent among all the harms-based exemptions in the guide, just making sure that the wording is the same and how we have laid out the two thresholds, because there's also two thresholds for harm in the legislation. There is reasonable expectation of harm and could harm. You'll see could harm in sections like 15 or 14 in LA FOIP, the law enforcement investigations exemption, and then also danger to others in the release of information. Those are coulds, but for the most part, it's could reasonably be expected to. So we've created a little more consistency. You'll see as it's laid out here in 19.1c, that is going to be consistently worded throughout the guide for harm-based exemptions. And there is a three-part criteria, and for those of you who are drafting submissions, it's very helpful if you speak to the harm that is being contemplated and each of these three parts. The first one is there must be a clear cause and effect relationship between the disclosure and the harm which is alleged. 2, the harm caused by the disclosure must be more than trivial or inconsequential. And 3, the likelihood of the harm must be genuine and conceivable. So now we're going to talk a little bit about 19.3 and some changes there.
So in section 19.3, we have updated this part to include a two-part test to consider when determining if an exemption applies. So the two-part test is as follows. The first part of the test is disclosure in the public interest as it relates to public health, public safety, or protection of the environment. Under this first part of the test, it also provides factors for public bodies to consider in determining if disclosure is in the public interest. The second part of the test is, would public interest outweigh in importance any financial loss or gain to or prejudice the competitive position of the third party?
Okay, and now we're going to talk about some additions to the personal information exemption. So at the beginning of section 24, as in the current version up on our website, we talk about the two criteria that are required for personal information to qualify. And one of them is you need to have an identifiable individual. So the information has to actually tie to somebody that can be identified. And two, the information itself must be personal in nature. There are a number of things that the current commissioner and former commissioner have found didn't qualify as personal information, and we've started to try to make your jobs easier by creating a bit of a running list of those things that have been found, in some cases consistently by our office, things that don't qualify as personal information. The first one is work product. It's information generated by or otherwise associated with an individual in the normal course of performing his or her professional or employment responsibilities, whether in a public or private setting. So, for example, if I was drafting a document for the commissioner and I signed my name to it, that is not Alex LaRocque's personal information, that is actually work product. Business card information, that is something that's consistently been found by our office not to constitute personal information. The things that you would normally find on a business card, your name, your job title, work address, work phone numbers, work email addresses, those are not considered personal in nature. Names of nurses and firefighters in review reports LA 2012-002 and F 2006-001. The names of nurses and firefighters were found not to be personal information. Position, function, responsibilities, or hours of work. Again, in some previous reports, those things have been found not to constitute personal information. For example, review report LA 2012-002. The other thing that we have found doesn't constitute personal information is signatures found that are made in a work-related capacity. Signatures that are done in the personal, outside of the professional context, could be personal information, but generally in the work-related capacity it's not, and you'll find that in Review Report 156/2015. So for those of you who attended the rollout, Danielle and I had let you guys know that for the subsections of Section 24, we would continue to try to grow examples of things that have been found to be personal information, definitions, things that have been found not to be personal information under the specific subsections. So we have now added a bit more here. For 24.1a, you're going to see the terms creed and family status. So we do have a couple definitions there now for you for creed and family status. In fact, for family status, in Review Report 109/2015, the Commissioner did define family status, and that came from the Saskatchewan Human Rights Code. For 24.1b, employment history, I mean, that's I believe in the guide that's up on the website now, but it's also something consistently defined by our office. Employee number. When linked with a name, it's found to be personal information because, again, you'd have an identifiable individual, and it's somewhat personal in nature. It's assigned to you, and usually it's attached to your personnel record and other types of things. Signing a petition. Found to be personal information because the individual is indicating that they agree with the petition by signing it. It would constitute the opinions or views of the individual. You'll see that in Review Reports 156/2015, and that might help you with 24.1f. 24.1k, that's there's no update there yet. That's still, we'll continue to flesh that one out as time goes on. So now we'll talk a little bit about possession and control.
So for this part of the guide, our office has updated this section to provide a two-part test for determining if a public body has a measure of control over records. So the two-part test is as follows. Do the contents of the document relate to a departmental matter? And 2, can the public body reasonably expect to obtain a copy of the document upon request? In answering these two questions, public bodies can also consider the 15 criteria also listed in the guide to assist them.
Talk a little bit about frivolous, vexatious, not in good faith. There has been a little bit of an update here. The definitions are still the same, but what has changed is the 5 factors. Well, it was 4 factors, it's now 5. The factors that we have on the current guide on the website is number of requests. We look at whether the number is excessive, the nature and scope of the requests. So are they broad, are they varied? That could actually indicate, based on what it is, what the intention of the applicant might be. The purpose of the request. Are they intended to accomplish some objective other than to gain access? And timing of the requests. Sometimes there's other proceedings going on that could indicate what the objective of the applicant is and whether it really is about obtaining access to information. The new one that's been added is the wording of the request. Are the requests or subsequent communications in their nature offensive, vulgar, derogatory, or contain unfounded allegations? So this is a new addition. It comes from some reports that we've been watching across the country, particularly one that come out of Alberta. And you'll see this new 5th factor in Review Report 053-2015. If you're looking for some general information about frivolous, vexatious, not in good faith, the very first one that had been put out by this office is F 2010-002. And one of the things that has also been adjusted is this part right here. Depending on the nature of the case, one factor alone or multiple factors in concert with each other can lead to a finding that a request is an abuse of the right of access. You'll find in the version up on the website that it says something along the lines of multiple factors in combination, but we recognize now that one request could be found to be frivolous, vexatious, not in good faith, depending on the circumstances of the case. So for those of you who are drafting submissions or looking at requesting that the commissioner dismiss a review or discontinue a review, you'll want to look at these 5 factors and figure out which ones actually apply to the circumstances of the case before you. You don't have to address each of these 5. You can if you wish to, but depending on the case, 2 or 3 or 1 of these factors might be really powerful, and that's really what pushes it over that threshold. So there actually has been a recent report put out by the commissioner that deals with the equivalent subsection of the Health Information Protection Act, that you will actually see these definitions and similar criteria for the Health Information Protection Act exemption, which is frivolous, vexatious, not in good faith. And that report is 225-2015. And now we're going to look at a change to correction, or an addition, I believe.
So under the right of correction, in the updated version of the guide, we provide public bodies with some guidance on the elements to include in a notation when a request for correction is not made. So notation should be permanent and obvious and should include the following. Should include the date, who requested the amendment, what the requested amendment was, a signature of the decision maker, and the reason why the notation instead of the amendment was made.
Now, fee estimates. So recently in Review Report 159-2015, the Commissioner recommended the following steps be taken when processing an access request and charging fees. And you'll find these steps at paragraph 15 of that report. So we're hoping that this provides some assistance to those of you who are wondering how do I approach fees? When do I issue them, and what are the steps? So hopefully this is of assistance to you. The first one is clarify or narrow the access request with the applicant. And the reason for that is if the applicant has that opportunity to narrow the scope, it will reduce the number of records, which the hope is it will reduce the fee. And you want to make a search strategy. And we have created a hyperlink here. If you click on that, it takes you back to the search section where search strategy is defined, and it gives you some idea of what should be in your search strategy. And number 3, based on the search strategy, prepare a fee estimate. You don't have to complete the work because it is an estimate. So basically determine where you have to go to find the records and what's all involved. Decide whether to charge a fee. And for that, you'll want to refer to your public body's policy. Hopefully your organization has one. Number 5, send out the fee estimate and suspend the work. 6, if the applicant initiates, clarify or narrow request with the applicant. Again, that is, assisting the applicant with somehow reducing the fee estimate through maybe the applicant getting more specific about what they actually want. And 7, when the applicant pays the 50% deposit, you can start the search. So if you don't receive that deposit, then that's an indication from the applicant that they don't wish to proceed. So it's on the applicant at that point. And last, we're just going to tell you a little bit about what might be coming in the next little while as far as more updates. We have, time permitting, a number of things that we want to start adding. And those include a section on what's required by Section 7 in FOIP and LA-FOIP. Timelines, what should be in your Section 7 letter to the applicant, third-party notices and rights. When you're dealing with third-party, it can sometimes get not super clear what the obligations are on your organization when you're dealing with third-party information and the timelines that are involved there. We're going to add a section on offense provision in both FOIP and LA-FOIP. We're looking at sections on duty to assist, Section 3, public records, and at some point we're looking also at adding a whole section on the protection of privacy, which is in Part 4 of FOIP and LA-FOIP. So that's our update for you at this point. We will be putting this updated version on our website right away, and again, just like we had indicated in the rollout, if you have any feedback or suggestions or things you'd like to see or things that you have questions about with the guide, definitely contact us. We're open to that, and we'll continue to grow the document and try to make it as helpful for you as we can. Thank you.
Thanks.